Hey, it's Chris here. In this episode, I want to discuss building contracts and what they should include for your protection and for the builder's protection. Contracts by their very nature are pretty boring, and believe me, I have read so many. And they include terms and conditions that most people will not understand, particularly at the time of signing. And because of that lack of understanding, this can create arguments and misunderstandings during your building project. I've been involved in projects where the client has no idea what is in the contract. The builder has no idea what is in the contract. And I'm not joking that when I say that one of those clients and builders was a large company building homes with a build value annually of over 100 million. So it's not just the little guys like homeowners that don't understand the contracts. It's not uncommon at all. One of the most common statements you'll hear when a contract is signed is that sign it and put it in the bottom drawer and forget about it. And while the sentiment of that is about assuming that both parties will do the right thing, it's quite common that at some point in a project the contract needs to be referred to resolve an issue. And a reminder for you that this episode is not legal advice and it's provided only for information purposes. Construction law is a very specific area of the law, so if you have issues with a contract, you should engage a construction lawyer. And don't forget to like and subscribe this video so we can continue to bring you quality content like this. So now let's jump in. Let's dive into the key criteria that a building contract should include. The definition of roles and responsibilities for the client, the builder and the architect is really important. So the contract will set out what the roles and responsibilities of both the homeowner and the builder are, ensuring everyone knows what's expected. In its simplest form, there is the client responsible for the entire project, typically including the procurement of the design, the consultants, procurement of the building team, and secondly, a contractor builder that has been tasked with the responsibility of building in accordance with the documents that the client has provided. The builder has legal responsibilities to build to the relevant building codes and standards applicable to the project as well. So they are all baked into a contract, or should be baked into a contract. Most contracts are procured by the client with assistance from the architect or building designer, or if it's an organisation that is developing a project, often there's a legal team that will prepare a contract specifically for the organisation that is developing the site. Note that contracts really should be a fair document that assigns risk to both parties respectively according to their expertise. In some contracts, however, such as design and construct contracts or projects with a volume of production home builder, many of the above items are completed by the builder themselves. Therefore, the client has a reduced role in the contract and often far less control of the project and how it is delivered. These types of contracts are often the source of heightened issues due to the contracts being written in favour of the builder. The contract should outline who is responsible for permits, materials, labour and other aspects of the project, and both parties have an obligation to understand what their role is and what is required of them. There is plenty of administration that is required from both parties. The scope of work and who is responsible for specific tasks. The contract will detail this scope of work, including what will and will not be included in the project. The scope of work included in the documents are typically things like town planning permits, development approvals, architectural drawings, structural drawings, geotechnical reports, finishes schedules, and often the builder's tender submission is included in the contract as well. I also like to include things like formal meeting notes after you have a tender submission and a tender review. These meetings can include a lot of discussion where parties say, look, sure, I can include that in the price, no worries. But it is not officially in the written tender document. I have found that this is very useful when a builder wants a job. They often have a throwaway comment in these meetings, and that you as a client can actually place a lot of weight on those comments. So if you don't include written notes in regard to that, well then it's clearly not going to be included in the contract no matter what they said in these meetings. Misunderstanding of this section can lead to disputes if the homeowner expects certain things or certain tasks that are not included in the contract. Failure of any party to the contract to complete their scope of work could lead to disputes, and in the worst case can lead to serious repercussions for the client or the builder. There could be major issues where a client or builder issues a show cause notice asking the other party, asking why the other party should not be terminated for failure to act in accordance with the contract. This is kind of the absolute worst case, but I highlighted here that a building project is a serious business with often quite a lot of money and risk at stake for the homeowner and also for the builder. Simply though, both parties have an obligation to understand what their role is and what is required of them. There is plenty of administration that is required, and most importantly, communication is essential to ensure that your project runs smoothly. Cost and payment terms. Super important for the client, super important for the builder. The contract provides the project cost, the payment schedule, and any provisions for changes or variations. Now, obviously the cost of the project is important to understand, and the contract should clearly state the full cost of the scope of works that the builder is covering for the project. The cost that a client incurs outside of the building contract will typically not be referenced at all in this contract. There are different approaches to payment terms for contracts, and some may be legislated to protect the client, particularly in a residential sense or domestic building sense. For example, a deposit of 5% is the maximum for anything over, I think, $20,000. And then you have percentage claims at base, frame, fixing and final stages. There's also different types of contracts where they allow for 30-day payment terms, and these are often only on larger projects where they're administered by an architect or a superintendent. These ones require expertise by the architect, or in some circumstances there's a quantity surveyor involved, and they come and assess the percentage complete of the works under the contract on a monthly basis. And then a report is issued to the builder. They will agree on a figure, and then the builder will submit their claim on that basis. In that circumstance, the client is giving permission to the architect and the superintendent or the quantity surveyor to make the decision on percentage complete. And typically, you will need to stand by that as a client if the experts are saying that X percentage is complete. Understanding these things within the contract will help homeowners avoid unexpected costs or payment disputes. Often this is the biggest trigger for issues when a client fails to pay on time as well. So you need to be as a client, you need to make sure that you're squeaky clean from a contractual sense. And conversely, there are some builders, I'm not saying all, there are some builders that seek to claim payments from a client when they are not due, and this is often happens in the domestic building world, where often clients will then pay the builder to keep on good terms with the builder. However, if you do this, you run the risk of paying the builder for works that are not yet complete. So for example, if you're paying for lock-up stage, for example, the builder's claiming it early and there's no windows in or there's no doors in, well, you're clearly not locked up, so you shouldn't be paying. Project timelines, start and finish date, that absolutely needs to be written into the contract. The contract will specify the start and completion date, along with the provisions for delays. This helps homeowners hold the builder accountable and manage expectations for when the work will be finished. And this is just as important as payment terms. Understanding when the builder will start and finish is critical. Your planning as a homeowner occurs all around this. The arrangement of your finance, arrangement of alternate accommodation if you're renting somewhere, if you need to move out during a renovation, or you're knocking down and rebuilding and you need to go and rent another home somewhere. You need to know what the finishes date is so that you can organise all of that. Now, coupled and linked inherently to that is management of the allowable delays is particularly another area of the building contract that can lead to major disagreements. If you as a homeowner or as a client don't manage these delays, you may well find yourself running late, which could cause you financial loss, such as additional rent that you need to pay. And understanding terms such as liquidated damages and what they mean and how they are implemented is critical. Warranties and defects. If there's no bigger trigger word in building, it's the word defects. It conjures up so many images, and at its worst, defects can be so bad that major rectification works can be required, which will cause financial loss for the builder and most likely the client. No matter how good your lawyers are, it's going to cost you something. But minor defects are normal. Building is not perfect. Homes are not built in a factory with precision like you would expect with a motor vehicle. Projects are undertaken by a builder with many sub-trades involved, which are always varied in skill. That being said though, there should not be many defects, but often there is. Many homeowners now outsource this to building inspectors to have the skills and knowledge of building codes and building standards to be able to identify whether an issue is actually defectively built item or not. I would actually recommend that homeowners use someone that is a third party to allow for objectivity in this review. This also can be completed by an architect if you're using one. The contract should also include information about warranties on workmanship and materials. There are implied warranties written pretty much into every contract, such as the builder confirms that he will use new materials unless otherwise nominated, that he will undertake the works in a professional manner, etc., etc. These are normally nominated in the contract or required under legislation. Other warranties include things like plumbing works, electrical works, where the subcontractor provides you with a certificate of compliance, and waterproofing also normally comes with a warranty that confirms that the works comply with the relevant standards. So understanding these couple of things too is really important if you don't want to get it wrong and lead to contract disputes. Termination clauses. How do you legally fire someone from a job? Well, in my experience, it's actually really difficult, and you need to follow the letter of the law and follow the letter of the contract. So the contract will include a section that sets out how this can be done from a client perspective, and then also from a builder perspective. They also have the right to terminate a client. If you ever get to this point, you know something has gone terribly wrong. But if you are in this situation, seek legal help from a construction law expert, because you have to follow the provisions in the contract to the absolute letter, and it's not something you can do by yourself. So please do not try to do this by yourself to save money. You will completely stuff it up, guarantee it. So if you just Google terminate my builder and see what comes up, pretty much everyone will be an ad for a legal firm telling you what you should and shouldn't do. And the last word, so hopefully you have some understanding of what a contract should include and the potential issues you will encounter when you have one. But also understand that if you don't have a contract in place, you have no legal standing or help. And here's what we covered. The definition of roles and responsibilities for the builder and the client, the scope of work that's required to be included within the contract, the cost of works and payment terms, project timelines and how important the start and finish date is for you as a client, warranties and defects, and lastly we covered termination clauses. So you need to thoroughly review and understand your building contract. You need to protect your investment. You need to set clear expectations with the builder and ensure a smoother construction process. Seeking legal advice before signing can also help clarify complex terms and protect your interests. I hope that's been helpful for you, just as an overview for contracts, and they can be quite tricky, and hopefully So as the last word, seeking legal advice before signing can also help clarify complex terms and protect your interests. And finally, a last word before you go. If you like this content, don't forget to like and subscribe to receive more. And if this has made you realise you need to know more about building, feel free to join our Home Building Mastery program, where you will receive content like this and more, including coaching and mentoring just for you. Head over to the link below at Fit to Build, and I hope to see you there.